Welcome, learner, to today's deep dive. So imagine for a second that you're a lawyer. For decades, the very foundation of your professional life, the way you actually generate value for your clients, has been rooted in this highly specific, highly tedious kind of physical and mental labor.
Yeah, lots of heavy lifting.
Right. You probably picture massive, leather-bound volumes of case law just lining the walls of some fancy mahogany office. And then, as technology progressed, that sort of evolved into sitting in front of a glowing screen for hours, just hunting through digital databases to find that one obscure precedent that could win your case.
I mean, it was slow, it was exhausting, but importantly, it was the absolute bedrock of the billable hour.
Exactly.
It was a business model built almost entirely on the friction of finding facts. Like,
Correct.
the more time it took to locate the relevant information, the more the client paid.
Yeah.
But the landscape of that friction is being completely rewired as we speak.
And exploring that tectonic paradigm shift is our exact mission today. We are looking at a really brilliant article from June 2026 by Charles Odendahl, and it's titled The Intelligent Search, Mastering AI in Legal Research. And the stakes laid out here are just incredible.
There really are.
The research maps out how generative AI is creating just unimaginable speed in the legal field, but simultaneously is laying down these hidden, devastating ethical landmines.
Yeah, it's a profound transition because on one hand, you have the promise of near-instantaneous synthesis of complex legal arguments, but then on the other hand, you face this genuine risk of professional ruin if you don't deeply understand the underlying technology, in its limitations.
Okay, let's unpack this by looking at how the day-to-day functional reality of a lawyer is physically changing before we get into the consequences of that change, because we are officially talking about the end of the keyword era.
Right, and to understand how big this shift is, we really have to look at how lawyers used to interact with data. Historically, digital legal research relied heavily on Boolean logic.
Oh yeah, the whole and or not stuff.
Exactly. It wasn't really it was more like rudimentary coding. You had to guess the exact phrasing a judge might have used in a ruling 30 years ago.
Which is wild to think about.
It is. You were typing things like breach of contract within 3 words of implied warranty, but not commercial real estate. It was just a very rigid, mechanical way of searching.
Right, because the computer didn't actually understand what you wanted. In the old days, if I searched car crash, the system wouldn't find a case that used the phrase automobile collision unless I specifically programmed it to look for both.
Yeah, because it didn't know the concepts.
Right. The database didn't know what a car was. It only knew the letters C, A, R, R. It's like searching a pitch black library with a tiny little flashlight. You only see exactly what the beam hits.
That is a great way to put it. It was a literal matching engine.
Ah.
But the fundamental shift highlighted in the text is the move from those manual keyword searches to large language models, or LLMs. These systems accept natural language queries. You don't have to speak to the computer in code anymore. You just speak to it like it's a colleague.
Yeah, which changes everything.
It does. You can ask it to find cases where a specific sequence of complex events occurred, and it actually understands the semantic intent behind your words. It's no longer a tiny flashlight. It's like having a fleet of super speed interns who can just read the whole library in 5 seconds.
I love that. And because of the sheer processing power of these LLMs, they can ingest massive amounts of case law in seconds. The text notes that an AI can instantly synthesize something like 20 relevant, dense legal cases into a tight, highly focused 2-page summary.
Yeah, instantly.
It's an inversion of the old workflow. Instead of spending 90% of your time searching for the document and 10% reading it, the AI does the searching and reading instantly and hands you the synthesis.
What's fascinating here is how this functional reality fundamentally challenges the traditional billable hour model.
Yeah, let's talk about that.
Because the billable hour is predicated on human effort and the passage of time. If a task that used to take a junior associate an entire week can now be accomplished by an LLM between sips of coffee, the economic foundation of the law firm has to shift.
It has to.
It forces the entire industry to reevaluate what they're actually selling. Like, are they selling time or are they selling insight?
Right, because you might be listening to this and thinking, well, if AI is doing 80% of the heavy lifting, why would anyone pay a lawyer $600 an hour?
Exactly. And that is exactly the existential crisis the industry is facing right now.
But here's my hang-up with all this. If this technology is so incredibly fast, Why can't lawyers just open up a browser and use the exact same public AI tools the rest of the world uses, to write emails or plan
Oh,
vacations?
because that leads directly into the first major track,
Yeah.
the absolute danger of general-purpose public AI. The research is very emphatic about this general AI is notoriously unreliable for strict legal work because of hallucinations.
Okay, yes, hallucinations. But let's dig into why it actually hallucinates.
Sure.
Because if the fundamental architecture of an LLM is a prediction engine, if it's really just guessing the next most likely word based on its training data, how can you possibly trust it with legal precedent?
You can't. Not out of the box anyway.
Right, because you can't just flip a switch in the code and turn off its imagination. When pressed for a legal precedent that maybe might not exist, it will just invent a case name, invent a docket number, and invent a ruling that perfectly supports your argument.
And the scary part is it will do so with absolute confidence. I mean, it sounds incredibly plausible, but it's completely fabricated.
Which is a career-ending problem.
A catastrophic problem, yes, if you were about to walk into a courtroom and present that to a judge. So the industry had to solve this. They couldn't just cross their fingers and hope for the best.
Right.
They created what are now called legal-grade AI tools. The market is currently being led by the big three in this space. That's Lexis AI, Westlaw Precision, and CoCounsel, which is made by Thomson Reuters.
Okay, so how do the big three actually stop the hallucinations if the underlying AI is still just a prediction engine?
They use a technical architecture called Retrieval Augmented Generation, or RAG.
Reggie.
Okay, yeah, or RAG. This is a crucial concept for anyone trying to understand the future of professional AI. Let's break those words down. Instead of letting the AI pull from the open, unregulated internet to generate an answer, RAG builds a strict wall around the AI.
Whoa, okay.
Right. So when you ask a question, the system first retrieves factual, verified documents from a closed, trusted legal database.
Oh, so it finds the real cases first.
Exactly. Then it augments the AI's prompt by forcing it to read only those specific documents. And finally, it allows AI to generate its answer based strictly on that confined universe of facts.
Wait, if the AI is strictly limited to an existing database, isn't that just a traditional search engine with a chat interface? I mean, we're kind of back to fetching files. What's the actual mechanical difference there?
It's a really great question, and the distinction is absolutely vital. A traditional search engine merely retrieves. It points you to a PDF and says, hey, here's a file that contains your keywords.
Right.
You still have to open the document, read it, understand the nuance, and extract the relevant meaning yourself. Generative AI with RJ doesn't just retrieve, it synthesizes.
Oh, I see.
Yeah, it reads those 20 verified documents, understands the semantic relationship between the conflicting arguments, and generates a bespoke, original piece of text, like a summary, a memo, or a counterargument. It's actually doing the cognitive labor of connecting the dots, not just handing you the raw data.
Ah, okay. So it's taking the verified, safe ingredients and actually baking the cake for you.
Exactly. Beautifully said.
But even with these incredible legal-grade tools, our source text points out that the technology isn't flawless, right? Hallucinations are drastically reduced, but they aren't entirely eliminated. And this brings us to the human element, the ethical mandate.
Yes, absolutely. The introduction of this sophisticated software does not in any way absolve a lawyer of their professional responsibilities. The American Bar Association, the ABA, they have very strict rules governing how attorneys must operate. And the text highlights a few critical ones that are really being tested right now.
Yeah, let's start with ABA Model Rule 1.1.
So Rule 1.1 is the requirement of technical competence. In the past, competence meant knowing how to file a motion, understanding the rules of evidence, or maybe knowing how to use email securely.
Right, basic stuff.
But today, technical competence means you must understand the mechanisms of AI. You must understand what a hallucination is and how RAG mitigates it. You cannot stand before a judge and plead ignorance if the tool fails.
You can't just say the computer did it.
Exactly. The computer made a mistake is just no longer a valid legal defense.
And then there are rules 5.1 and 5.3, which deal with the duty of supervision.
Correct. These rules mandate that law firm partners must supervise the work produced by their subordinates. The crucial argument here in the text is that this duty now formally extends to automated systems.
Oh, wow.
Yeah, you have to supervise the AI exactly as you would supervise a human employee.
I think the best way to visualize this is to treat the AI like a brilliant but incredibly reckless junior associate.
Oh, that's a perfect comparison.
Right. You have this lightning-fast new hire. You love their output. You love that they can draft a 50-page memo in 10 seconds. But, they have a habit of occasionally bending reality to make a brief look better.
Right, they get a little creative.
Yeah. So how does a senior partner actually supervise that human associate? They don't just ask, hey, is this true? They demand to see the original case file. They spot check paragraph 4. They verify the citations. The text argues you have to apply that exact same managerial friction to the software.
That is the perfect operational mindset. You would never submit that junior associates' work to a judge without verifying the citations yourself, because at the end of the day, your name is on the document.
Yeah, your professional license is on the line.
Exactly. AI must be treated as a first draft assistant. It is a powerful starting point. It accelerates the workflow, but the human expert remains the final authority. The AI said so is never going to hold up in court.
So we've covered the risk to the court, right? The accuracy problem, the fake case is the output. But our source text brings up another risk that feels even more insidious because it happens entirely in the background.
Yeah, the data side.
Right. What about the input? What about the risk to the client when you're just typing into the prompt box?
This is what the author refers to as the privacy perimeter, and it is arguably the greatest hidden risk of using AI in legal research today. It fundamentally comes down to data leakage.
Explain how that leakage happens, though, because if I'm a lawyer sitting in my office typing a prompt into a computer, it feels entirely private, like it's just me and the screen.
It feels private, sure, but with public AI tools, the architecture is actually designed for extraction.
Extraction.
Yeah. The business model of many public AI companies involves training their future next-generation models on the prompts that users are entering today. They ingest your questions, your formatting, and your raw data to make their systems smarter for tomorrow.
Man, that's a massive vulnerability. So if a lawyer takes a highly confidential litigation strategy, let's say, they are representing a massive tech company in a secret, unannounced merger, and they paste that strategy into a public AI and ask it to summarize the weak points, what happens to that text?
The data is no longer private. It has been absorbed into the public training set.
Oh, wow.
And this is a direct, undeniable violation of ABA Rule 1.6, which is the ethical duty to protect client secrets.
Just by pasting it in.
The moment you hit enter, you have breached attorney-client privilege. Because you handed highly sensitive, unencrypted data to a third-party algorithm.
That is terrifying.
And the real danger is that the algorithm might inadvertently spit that exact data back out to a different user, perhaps opposing counsel, a month later when they ask a related question.
So it's a complete inversion of a lawyer's primary duty to protect their client. So how do firms actually build a perimeter to stop that? Because clearly, they aren't going to just stop using AI. It's too useful.
Right, they can't go back. The solution is implementing strictly closed AI environments. The text specifically points to tools integrated into enterprise platforms like Microsoft 365 Copilot or specialized legal-specific cloud servers.
Okay, closed meaning isolated.
Exactly. In a closed environment, the licensing contract explicitly stipulates that your data is cordoned off. It is never used to train the public model. When your session ends, the prompt data is completely wiped. It stays locked within your firm's own digital vault.
Here's where it gets really interesting, because the text points out that setting up this digital vault isn't something your average neighborhood IT guy can handle.
Oh, definitely not.
You can't just buy a premium software subscription, hand out a bunch of passwords, and call it secure. The author introduces the necessity of an MSSP, a managed security service provider, and emphasizes they need to have a legal lens.
Yes. The technical architecture required to safely run AI at a law firm is deeply complex and highly regulated. An MSSP with a legal lens understands the specific compliance environment the firm operates in. They aren't just there to fix the Wi-Fi.
Right.
Their job is to ensure the firm's data infrastructure is continuously audit-ready.
Let's talk about the mechanics of that, because the text mentions setting up conditional access and strict encryption rules. Conditional access isn't just a strong password, right?
Far from it.
It's a mechanism where the MSSP configures the system to verify your identity contextually. It checks if you are on a firm-issued device, it pings your IP address to ensure you are in a secure, known location, and it evaluates the security posture of your laptop before it even allows the AI prompt box to load on your screen.
Precisely. It is a zero-trust security model.
Zero trust.
Yeah, and on top of conditional access, the MSSP ensures all data in transit is encrypted. Furthermore, they provide 2047 monitoring to stop unauthorized third-party applications from scraping the firm's data.
Like what, for example?
Like a random browser extension someone accidentally downloaded. The MSSP stops that extension from essentially reading the firm's research data while it just sits on the screen. It's like having a dedicated cybersecurity strike team protecting your internal brainstorming sessions.
And that level of hardened security is what actually unlocks the value of the tool. I mean, if you are terrified of leaking client data, you won't use the AI to its full potential. You'll only use it for generic queries.
Right, you'd hold back.
But if you have an MSSP actively hardening your perimeter, you can feed it your most sensitive case files and innovate with total technical confidence.
Which brings us to the ultimate result of all this integration. I mean, we've talked about the tools, the legal grade AI and OREG.
Yeah.
We've talked about the rules, the ABA ethical mandates of competence and supervision. And we've talked about the walls, the closed environments, and the MSSPs. So when you put all of those pieces together on the board, how does it reshape the actual business battlefield of the legal industry?
It creates an entirely new competitive landscape. The text argues that the primary driver behind all this AI adoption isn't just novelty, it's extreme efficiency.
Efficiency is everything here.
We talk about how associates can synthesize 20 cases into a 2-page summary instantly. But practically, that shifts the firm's entire economic engine away from the time spent finding data entirely over to the cognitive effort of interpreting it.
Exactly. The manual, grueling grunt work is completely automated. This allows everyone, from junior associates to senior partners, to immediately elevate their focus to high-level strategy.
Which is what clients actually want to pay for.
Right. They can spend their hours drafting highly nuanced legal analysis that is intimately tailored to the specific messy facts of their client's situation, rather than wasting days just finding generic precedent. Furthermore, the AI is exceptionally good at identifying anomalies at scale.
All right, the outlier rulings.
Yeah. An AI can scan 10,000 cases across 50 jurisdictions in seconds and flag the one obscure ruling that breaks the established pattern.
Wow.
A ruling that a human associate, suffering from eye strain at 2 a.m. on a Friday, would almost certainly miss during a manual keyword search. The AI essentially brings the needle out of the haystack and places it directly on your desk.
So what does this all mean? When you step back and look at the market, AI isn't just a fancy new word processor. It's a massive structural equalizer.
It really is.
The text points out that this efficiency allows smaller teams to compete for the kind of complex, document-heavy litigation that used to be strictly reserved for global corporate giants.
Yeah.
It's a true David versus Goliath scenario.
Completely.
A boutique firm of 5 highly skilled lawyers, armed with legal-grade AI and secured by an MSSP, suddenly possesses the research output capacity of a 50-person department at a mega firm. They can swing incredibly far above their weight class because the software is doing all the heavy lifting in the background.
If we connect this to the bigger picture, the ultimate conclusion here is that AI in legal research is the most significant leap in practice management since the invention of the internet itself.
That is a huge statement, but it makes sense.
It takes ethical caution and hardened digital perimeters, things that usually feel like administrative burdens or just red tape, and turns them into a massive competitive advantage.
Because it lets them move fast and safe.
Exactly. By choosing the right legal-grade tools and aggressively securing your data, a firm doesn't just fulfill its fiduciary duties to its clients, it fundamentally outpaces the competition that is still clinging to the friction of the old ways.
It's an incredible transformation to witness, watching an entire profession rewrite its foundation in real time. And it leaves you with a really fascinating, provocative thought to mull over.
Oh, yeah?
Yeah. If generative AI truly levels the playing field between a tiny boutique firm and a massive global giant by instantly synthesizing all the knowledge they could ever need, how will those prestigious mega firms justify their massive retainer fees in the future?
That is the million-dollar question.
Right. Is the true value of a lawyer about to shift entirely away from how much information they know and move entirely toward how creatively they think about the information the AI provides? It is a brave new world for the legal profession. To you, the learner, thank you for joining us as we explored the shifting architecture of legal strategy. Keep questioning, keep exploring, and we will catch you on the next deep dive.